Good morning, everybody. We are Group 3 in Info 5720, and today we're going to be learning about copyright laws and internet safety in our presentation, Learning Copyright from Copywrong. So some of you are probably wondering, why do we need to know about copyright? But you as journalism students and citizens of the United States must know, for both ethical and legal reasons, all about copyright and how to do it properly, about using the fair use exemption and ownership of all intellectual property. So the state tells us we need to know about copyright law, but we need to know about it and be able to use it. So we must cite sources whenever we use work that has been created by somebody else. Otherwise, it's considered an ethical and a legal violation. So today we're going to be learning all about the foundations of these laws, and we are going to be demonstrating our understanding of those also. Starting with this little quiz. So go ahead, click on this quiz, and when you're finished, we will start our presentation. The first and most obvious thing we need to talk about today is what is copyright. So from the copyright.gov website, this definition: copyright is a form of protection grounded in the U.S. Constitution for original works of authorship fixed in a tangible medium. So that's technical. In other words, it means that people work really hard to create their own literary works, art, poetry, articles, anything else you find on the internet, and they deserve the money that they make off of their labor. So it's not our right to steal that from them. Copyright prevents others from taking their work for free or altering someone else's work without permission. So the history of copyright spans at least 4 centuries. The Statute of Anne in Great Britain in 1710 was the foundation and inspiration for the United States' eventual copyright law, enacted a few years later in 1790. And it's really stayed pretty steady since then, and which just goes to show how important copyright laws are for the citizens of our country. The U.S. Copyright Office issued updated information last year on works subject to copyright, or what can be copyrighted. So these include literary works like books, novels, stories, or articles, musical works and accompanying words such as compositions, songs and lyrics, dramatic works and accompanying music such as plays and musicals, pantomimes, choreographed routines for dance and movement, pictorial, graphic, or sculptural works, motion pictures or movies, or other audiovisual works, sound recordings, which are works that result from the fixation of a series of musical, spoken, or other sounds, and any architectural works, including blueprints. So here we have a visual representation of copyrightable materials. You see there's literary works, paintings, photos, drawings, films, music, choreography, and sculptures. So if you created any of these things, you have the option and the right to copyright it and protect your creation through the U.S. Constitution. So let's take a minute and discuss these. So who can tell me an example of a film protected by copyright law? Pretty much all of them, right? So what about choreography? Do you think maybe music videos are copyrighted so other people can't just hop in and do exactly the same thing and make a profit off of it? There are so many options for created works to be copyrighted and protected. So for as many works that can be copyrighted, there are also copyright limitations. So one of these terms is expiration, and that means that works can only be copyrighted for a limited amount of time, and that's usually 75 years after the creator's death. Work becomes public domain. Now, the term public domain refers to creative materials not protected by intellectual property laws, like copyright or trademark or patents. And the public owns these works, not an individual author or artist. Anyone can use a public domain work without obtaining permission, but no one can ever own it. Orphan works mean that the owner of the creation can't be located. Fair use, we're going to talk about later on, is the use is up to users' discretion. Parody means that the work trying to be copyrighted is to poke fun of something. And then things that can't be copyrighted are like quotes or sayings. So along that same idea, works not protected by copyright are, like the quotes or sayings, ideas, procedures, methods, systems, works that are not fixed in a tangible form. So you can't just like think of an idea and copyright your thought. It has to be recorded or notated. It has to be written down or recorded in some fashion. Titles, names, short phrases, familiar symbols or designs, unless it is an official trademark or logo. You can't copyright lettering or coloring, and you can't copyright like a recipe or something, just like a list of ingredients or contents. Copyright invalidity is a very common defense. It means that the work was not original or it lacked copyrightable matter. So you can't take something from somebody else and try to copyright it yourself. It has to be completely original by you. An independent creation, which means that two people are separately working on similar work. They cannot both copyright their own work. And then admission to copying means that the user admitted to copying but claims the amount used was very small. And look at some examples. This first one just spells out copyright infringement, but what are some things you notice about it? Those are all trademarks, those are emblems, and I'm willing to bet you recognize almost every single one of them as belonging to some sort of a company that makes profit from what they are selling, and that trademark represents them. So that is copyright infringement, to use those symbols because they are part of that company. The next one is this. Why do you think this is copyright infringement? You can see that they are extremely similar. You see on the left Starpreya coffee and on the right Starbucks coffee. And Starbucks is suing Starpreya because they are claiming copyright infringement, that their customers, Starbucks customers, are being fooled into going to Starpreya because they think that it is Starbucks. So they think Starpreya is taking profits away from their company by using their brand. Same thing with this. You see McDonald's on the left, McDowell's on the right. Extremely similar. And people could walk into a McDowell's thinking it's McDonald's. And so they are making the profit instead of McDonald's because of their similar trademark. Now this one I think is kind of crazy. You see on the left, you see Balenciaga heels. On the right, you see Steve Madden heels. The price difference is $4,000, but they are extremely similar. So the copyright infringement that's going on between these two companies is that Balenciaga is saying Steve Madden is taking the profit away from them by offering a copycat shoe for much cheaper, so people aren't needing to buy pretty much the same exact shoe for $4,000 more. With respect to trademarks, there is a violation when you use a trademark without the authorization of the owner. So like the ones we were just talking about with McDonald's or Starbucks. So to be more specific, The infringer uses a trademark which is confusingly similar or identical to a trademark that is already registered. So when this happens, people who buy certain goods or use the services will not be able to distinguish between the brands. Hence, the owner who has the trademark registered will face losses. And that's what putting in trademark laws is all about, is just making sure that creators get the money that they deserve for the work that they have put in. But infringement can only take place if a trademark has been registered. So a trademark owner whose trademark has not been registered can't bring an infringement suit. One important thing to remember is that all materials on the internet are copyrighted unless stated otherwise. So you cannot download, copy, or share any work without citing the author and using it for educational purposes. So what does all this mean for what we can legally copy or use in our journalism class or in everyday life? So we touched on fair use earlier in the presentation, but really what it is that it's the gray area of copyright within the classroom. So this is very important for y'all to listen to. So fair use for educational nonprofit purposes, like a teacher may copy a class set of material that is copyrighted for a very specific period of time and only for students in class, not general public, only for a specific number of students for a very specific amount of time. A fair use entertainment example may be the use of photos, music, or videos in a classroom are permissible for use as long as instruction is occurring. And so if it is used for education, it is permissible, but it must be free. A teacher can't charge to show a movie in class that goes along with the book that they just read. So another example of fair use would be smaller portions. The authors are more lenient on copyright rules within the classroom when small portions of their work are used rather than large portions. So they would be more acceptable when you're using just maybe a chapter of a book instead of copying the entire book. And teachers should not show videos, just for example, Pride and Prejudice in their classroom using YouTube or something. They should legally obtain a copy that does not negatively impact sales of the creator's work. So they should not use a copied material already. They should obtain the work legally, and then they are able to use it in their classroom for a very specific amount of time, very specific number. We also earlier touched on intellectual property ownership, which is not carefully or responsibly cited material is considered plagiarism and is an extremely serious infringement. And I know you guys have heard about plagiarism before, but you need to listen very closely, because when in doubt, always ask permission. If you have to ask permission to use another individual's work, be specific about your exact intended use, how much of their work you'll be borrowing, and just as a warning, there might be fees, but they could be negotiated if used for certain purposes. So in communicating about copyright, be sure to keep records of all your correspondence. The most important point of this entire presentation is to ask permission and cite everything, because it has ethical implications and legal implications if you are out there stealing somebody else's work. And so, you know, as an example, at the end of this presentation, we have our references list for all the photos we use, where we found all the information, where we paraphrase, where we got quotes from. We are citing everything, which is giving credit to the authors of this work, and that means that we are not taking credit for somebody else's work. Are there any questions?